of God. This is Brother Devon inviting you to check out Kingdom Principles on Fridays from 7 to 8 p.m. on Isaac 98.1 FM. We invite you to listen and to join the conversation as we discuss various topics in light of Kingdom Principles.
You'd usually hear this time in the next hour. I'm holding down for JL. I've got Devon in the house. Good evening and welcome.
Good evening, Madonna. How are you doing?
Good. How are you?
I am good. I'm hungry.
What's the heat doing with you?
The heat is doing well. Oh God, no, the place is real hot, you know? The place is really, really hot. I had to go and buy a air conditioning unit, portable. I never thought I would have done that in my life.
Portable one?
I buy the portable one. We could talk that out. Okay. Yeah. I want to get one. Wait, and it's good, eh?
Yes.
It's working.
Yes.
You would like yourself if you get that.
I'm gonna get it.
The heat is unbearable. But anyway, we are here. It's good to be here. Good to see you, Madonna. Good to see Grong. All right.
Same here.
Yes. Love in the house, guys. We are doing our part 2 on this topic entitled Prenuptial Agreements, and we are streaming on Facebook and YouTube as we speak. Guys, we are very, very excited for this topic because we have a special guest. we have a special guest in studio. See, Madonna already dancing, so she definitely in tune, right? We have a special guest in studio, none other than attorney at law Whitney Andrews. And she has a husband inside, so we just shout out to her husband, Mr. Akeem. How you doing? You alright? Excellent. So, and Whitney, say hello to our guest. Say hello to 98. Welcome to the studios of 98.1 FM.
Well, hi, good night, everybody. I am so excited, happy to be here. You know, as I told Devon before, being on the radio was like something that I was always excited about. So, just glad to be on the radio.
I'm glad to have you as an attorney. Trust me.
I don't know if there's a good thing or a bad thing.
No, guys, we started a conversation since is it about 2 weeks ago, because last week we had the open forum, and week before we started this conversation on prenuptial agreements where persons were surprised with a bit of information. I know Grong was surprised, JL was surprised on some stuff, and we want to continue the conversation this evening. So here is how we are going to do things, right? We are going to have the conversation for about 15 minutes thereabouts. You know, we try to work it for 15 minutes, okay. And then we will open up the phone lines for persons to call, give your comments and so on. Send your WhatsApp messages. Remember, when you are giving your contributions, whether you agree or you disagree with anybody's contribution, make sure and maintain respect. Always remember that, everyone, right? So let me give a little bit of a bio on our awesome guest here. Whitney Andrews is an attorney who works as a judicial research counsel at the Family Court of Trinidad and Tobago. In her role, she works alongside family court judges and masters, conducting legal research, opinions, judgment, drafting, and more. Beyond her legal career, she is married to her loving husband, and together they have one son. Bless God for that. She has been serving the Lord for over 17 years, completed her first year of Bible school at OBIT, which is Open Bible Institute of Technology, and fellowships. Theology, thank you. Thank you for that correction. And fellowships at the Koki Open Bible Church. At her church, she is on the board of deacons and serves on the leadership team of the young adults ministry. This woman here is.
I know her pastor.
Yeah. This woman is doing it here. Whitney firmly believes that her legal profession is not just a career, but also a calling to serve within the body of Christ. Accordingly, she utilizes her legal knowledge and expertise to promote reconciliation in marriages and the restoration of families. So that's a bit of bio there from our dear sister and attorney over here. Before we get into the meat of things, and we already have people logged on with me. You see, we know that person there?
Yeah, yes. Good night, Tyrion. Seeing you logged on.
So we have persons already logged on, looking out for this conversation. We have to give a scripture before we start. Mark chapter 10 and verses 6 to 9. Let's see if I could find that very quickly. It says, "But from the beginning of the creation, God made them male and female. For this cause shall a man leave his father and mother and cleave to his wife, and they twain shall be one flesh. So then they are no more twain, but one flesh. What therefore God hath joined together, let not man put asunder." So this is our starting scripture this evening, and Whitney, we want to jump directly into the conversation with what is a prenuptial agreement. I made some comments last time, and I want you to speak on that, and we just let the conversation flow, right?
Yeah, well, I mean, Davon, as I told you last time, to me, was doing an excellent job, because you kind of hit the nail on the head when you were explaining what is prenuptial agreements. And you know, before I give you like a definition of what it is, I think it's noteworthy to say that prenuptial agreements and postnuptial agreements and separation agreements, for anybody who would have heard these terms, all these things fall under the umbrella of what we call in the law as ancillary relief, right? They will fall under that, which is what we know as, well, I'm gonna go to court to see if we could share the house, split the house in half, or if I could get my payout, or what lump sum I could get. All those things are called ancillary relief applications. So just to bring the legal context into it.
Legalize
right?
us.
But prenuptial agreements are basically agreements that a couple would enter into before they are married, and the agreement would speak to how they would devise or divide the assets upon divorce. And some agreements would even speak to where the spouse dies, so there will be divorce or death, just the division of the assets, financial arrangements as well.
Oh, excellent. So we find out that I wasn't going crazy last time when I came on.
No, you actually, I was like, but Devon, you have some type of legal training or something, But
I make sure I do my research. I make sure I do my stuff. But you are hitting on some very important points for us to understand that it's not just one word or one terminology, but they are different terminologies.
Correct.
Could you give us back those terminologies just in case anybody may have missed it?
So the overall heading or umbrella is nuptial agreements. So we have prenuptial agreements, which is before you get married. We have postnuptial agreements, which parties might enter into during the marriage if they intend to stay together, or if they decide that we are going to separate and we are going to be divorced, then we have something called a separation agreement. So it's prenuptial, postnuptial, and then separation agreements.
Wow. So we need to be informed, educated about these things. Do a lot of people get themselves involved in these agreements, or is something that rarely people go after?
Well, the thing about it is, it just depends on which jurisdiction you engage in the court in. So, for example, if it's the states, well, we know obviously we have heard countless times the celebs, you have to get a prenup. You're not going to get married without a prenup, right? We have countries like Canada, Australia, France. These countries endorse, as in they say, listen, prenups are legal, legally binding, enforceable, go through. But then when we have Trinidad, right? I'll just say Trinidad.
Yes,
right?
Let me find out. But now, did you have anything you wanted to ask?
I just agree with at a particular age in life, At least if you're starting over, and that kind of thing. Because I had the topic on the others, and
you
a
did?
lot of it, a lot of it came out with mature persons who would have accomplished a lot in life, and then met someone and they found it difficult. And this was a whole survey going crazy that night.
Yeah.
In that they are not accepting that somebody should just come and want what they they have and be tied into what they have after they have worked hard and accomplished all this over time. So I know that's a census a lot of listeners would have had. And that is, I say, based on the age, because my market would have been for older persons and stuff like that. So persons would have accomplished the house and all these kinds of things, and they're like, but why? No, he has to have a house as well. He can't just come and want to. And one or two are saying, they wouldn't mind. But the majority, based on that program, it was they were saying nothing. I mean, Lynette and Tobago, good evening. Yeah, because a lot of them were saying not after.
Well, I mean, you do find that persons who have had more than one marriage or more mature persons would want to put a prenup in place as a safeguard. But when we think of a prenup, we need to have in our mind that, okay, what assets the prenup designed to protect them, and what assets would be up for grabs. Let me use that loosely. Up for grabs if I go to court after a divorce. So if I have a divorce, the assets that are up for grabs are those in time from the point like that you got married, the date of your marriage. Not the ones that you had before. Those are not matrimonial assets. So if you are a mature person and that you would have got your house and all these things, or probably, I don't know, your car, whatever, your business or whatever the case is, before you got married and you decide to get married to this person later on in life, those things are not matrimonial assets.
But
So
people still go after it because
they would okay, so they would go after it in the sense of they would use that as a leverage to say, I want to get a quantum that reflects my investment from the point in time with which I would have gotten married to you, which is not unreasonable. If it is, you would have had this business before me and I would have come alongside you and help you grow this business.
Right.
You think that's unreasonable?
No, but listen, I heard of situations, because I'm all up into this, you know what I've been doing.
Yes.
And I've heard at least 4 persons who would have had their homes in particular affluent areas, would have married somebody else, would have been their other marriage, and the spouse would have wanted money from what they would have claimed they would have contributed, and actually won the house, want half. You understand? When obviously at one loss, one win, I mean, he was blown out of the water, he couldn't believe that happened. And so therefore persons are very concerned now, because they don't think that is being protected, especially the one who lost, because it was like, she met me with this whole house, and how could they then say she entitled to half and he had to pay her half?
Well, you see, that's the thing, because we have the mind that if you get married to the person, it's about the 50-50 and what is equal, but that is not the law.
You see, and we were talking about that even in the part 1, because Ground and Jail were asking if you're getting that 50-50. Ground probably in the car listening right now and shaking your head. So that 50-50, speak to us about that, clarify that understanding.
So, okay, in Trinidad and Tobago, because remember, we need to be real with what is our legal situation here.
Right.
The law that governs any type of financial arrangement on the decree of a divorce, right, is the Matrimonial Property and Proceedings Act. And the legislation spells out in section 27 together with the case law. And for my legal persons listening, I'll say the case as well, which is Passad and Passad. It says that it is what is equitable, not equality. So we have a period in time where the law has transitioned. So before it used to be wanted, then it was the half and half, and then it reached to what is equitable.
I wonder what was the wanted. Who was getting wanted? I wonder who was getting. I have a guess, but I'll leave that.
I don't know if you're trying to say that the men was getting wanted.
Yes, that's what I'm trying to say.
No, actually, that was not the case. No, because during those times, the women were at home with the children. And at that time, it was said that the contributions that would have increased your award at the point of divorce would have been the financial contributions. And they did not consider
The
women working from home as a contribution. So it actually was the woman who was getting
That hard.
the lesser quantum in that case. But yeah, so in Trinidad we don't have this. It is erroneous to say that you have to split it 50-50. Now, depending on, there are different considerations that the legislation spells out. And let me just read them out for you, right? It's 8. So if the court has to exercise its jurisdiction to decide, okay, how am I going to divide the assets that these persons would have had based on the length of their marriage and all of that, right? The prenup is just but one factor that the court might consider, but it is not the only factor. So therefore in Trinidad, we cannot say that prenups are enforceable automatically.
Really? No, that's not fair. Justice,
Our law,
good evening.
our legislation has not gone to that place where we automatically recognize prenups as valid and enforceable. Now, parties are free to go ahead and enter into the prenuptial agreements. They are free to do that. However, when they get to the court, the court has to decide whether or not they would attach any weight to the agreement.
Pause a
That's
sec.
unfair though. That's unfair.
Unfair to who?
Unfair to us.
The
who want
parties.
to-
And this is why there has been reform in certain countries like Jamaica, for example. Jamaica, the legislation endorses prenuptial agreements.
Hyacinth, I know you're all into reformation. Good evening. I will suggest you start this drive for
Yeah, but
reformation of
our law in Trinidad and even the common law that we follow, which is England and Wales, prenups are not automatically enforceable. Now, there are times when the court would give effect to the terms of the prenup, but that does not mean that because it's not automatic. So you could make your prenup, but if you decide that you want to engage the court to make an order reflecting that prenup or to force another person who's saying, well, let's use an example. The person said, okay, we get married, we will enter into this prenup, things go south. Then one person say, we have a prenup, we need to stick to this. And the other person says, well, no, I don't agree with this, I don't agree with that, I'm not enforcing that.
and they go to court.
And they go to court, right? They go to court now. When they go to court, the court say, okay, the jurisdiction that I have must be exercised in accordance to Section 27 of the Matrimonial Proceedings and Property Act. And that says, let me tell you, it says, in deciding whether to exercise its powers under Section 24 or 26 in relation to a party to the marriage, and if so, in what manner, the court shall have regard to all the circumstances of the case, including the following matters. Now, mind you, prenup is not listed as one, so just in case anybody thinking that they're going to hear that here. So, this is what they consider when they have to weigh the evidence before them, look at the facts, listen to the testimony.
Pause. Because this is a lot of information. Let's make sure, and we are going to open up our phone lines very soon. We have a message coming in from, is this Atkins? He says, and prenups are safeguards. People are greedy out there and want more than they brought in. If prenups are not automatic, then does the existence of prenups make sense?
Well, and you see, that's the thing. We have to understand what is relevant in our jurisdiction.
That's right. Yep.
Prenups do make sense in the jurisdictions where they are automatic. Prenups can make sense to a degree in Trinidad if the court attaches weight to the prenup and gives effect to the intentions of the party.
So it's up to the court to make that
That's
decision.
right. And there are surrounding circumstances that they will consider.
Yeah.
Now you see what she calls in Trinidad and Tobago. Not her, but the law. Because this again was another topic. My money, your money, our money, what's going on here. Now this now, with this awareness, would cause persons to really want to have a separate account. Just in case.
Yeah.
And nothing is wrong with that.
No, nothing
you
wrong,
know?
yeah.
And
We have to open up the phone lines because we want to hear your take on this. In the meantime, while persons deciding what they want to say, I want you to finish what you was reading there. Let's really focus on what the courts are going to consider as our attorney, our guest here, Whitney, has said the prenup is not a part of this particular consideration.
No,
About the courts. Okay.
it would just be one. Hey, Jill, I see that girl.
Okay, we have a call coming in. Let's take the call.
Hi, good evening. Hello?
Hello, good evening.
Good evening, caller.
Evening,
I don't know. I'm not hearing.
You know,
I want to find out, like, if I have a property, right? Like, me and my wife have a property and I come and die and our children decide not to see. There could be a problem to get the property.
yeah, he said if his wife has a property and he comes, if he has a
I
property,
think- No, I say if I have the property
right?
and I come and die and my wife, that is my wife, and our children outside, they could come and give you trouble for the property.
I didn't hear what he said.
He said he has property. Okay, caller. So you listen off here, right? He said he has property. He wants to know if he comes and die and he has children outside, if they could come and give his wife problems in getting the property and they would want it shared and that kind of thing.
If he doesn't have, okay, first of all, this is not legal advice.
Yeah, first thing. Yeah.
Go to an attorney, they would have all the facts before them.
I
They
forget
can
to say that.
ask the different questions, probe you. However, based on what you have just shared, if you do not have a will, then based on the rules of intestacy according to our law, the wife will be the person next in line to inherit the estate. The children, if the wife don't exist, then the children. But if you have a will and you put the children on the will, then the children will get whatever you state in the will. But the rules of intestacy is that no will, the wife.
One thing to mention, and this is just of an experience as well. The wife is entitled, they say, to half, and the children gets the other half to be divided equally once she names them in the estate. So that happens as well. So
Yeah.
the children will have a right to be entitled to part, but the wife will have the majority of
Yeah,
it.
yeah.
Okay. We have another call coming in. Hello, caller. Good evening. Welcome to Kingdom Principles.
Very nice. A question I want to ask you again is that if you have a property, right, and somebody has life interest on the property, and you have two houses on the property, but one is your house, and you give the person staying in your house, but they have a house and they have life interest, which is brother and sister, and they have a life interest, the parents leave that for them, and the person now rent somebody the place, right? They have life interest in the place. Them is not the owner, they just have life interest in the place. And they rent somebody the place. So when the person die now, who rent them the place, who are the life interest? The renter could give trouble to the person, to the owner, because not the owner rent them, and it's the person who has life interest.
Like, caller, what you're explaining to me there is real property law. We're not actually addressing that tonight. We are talking about prenuptial arrangement, so you would need to seek legal advice. You need to go to an attorney and explain that position that you have to them, and they would advise you accordingly. We can't do that on the air. We can't do that on the air.
Yes, and let me take the opportunity, as I didn't do it earlier. This is not legal advice. We would encourage, as Whitney would have already said, that you go to an attorney to break down your situation.
Attorney.
Attorney.
Not attorney.
That's it. That's it.
You said attorney.
I said attorney. I feel like the hunger.
You're mixing it tonight,
attorney. I know I meant to say attorney. Anyway, yeah, you go to an attorney and explain your situation, and then you could get the proper legal advice. We are sharing some information tonight, so just stay within the topic and everything should be fine.
Yeah.
All right.
So back to what I was saying
Yes,
before,
yes,
which
you can
is
continue reading.
what the court considers when they are going to divide the assets amongst the parties.
Yes.
And this is in the legislation, by the way. So the first one is the income, earning capacity, property, other financial resources which each of the parties to the marriage has or is likely to have in the foreseeable future.
Okay.
So this is concerning what you have now and what you're likely to have, right? The second one is the financial needs, obligations, and responsibilities which each of the parties to the marriage has or is likely to have in the foreseeable future. The third one is the standard of living enjoyed by the family before the breakdown of the marriage. So you can't want to come into the marriage or they living like top dogs, enjoying on yourself, pool, everything. And when you want to divorce, no, you basically said, well, no, you have to go and rent a little apartment somewhere. No pool, nothing.
Wow.
You understand?
We have one call. Hello, good evening.
Hi, good evening, guys. Madonna, Davon, Whitney, Akil.
This name
JL,
sounds
yes. What you're
familiar.
saying is no 50-50. So we can't do this 50-50.
JL,
I just want to know.
we miss you
I
here
just want
tonight.
to know.
No 50-50.
It is not automatic. It is what is equitable. So equity would have it that if one party is going to have undue hardship or be disadvantaged by the 50-50, the court will go 60-40. They will go 70-30. If one, for example, I had a matter where the house was built on the guy's land, and the wife would have undertaken the financial obligation to seek the mortgage, the loans, everything, right? And he could have do like construction and stuff. So he was doing the physical part of it, building the house. However, if it wasn't for the wife going and taking out the different loans, etc., they would have never been able to buy the material for him to build anything anyway. Right? And even though it was on family land, and in that matter, the assets was split 70-30 because the guy did not put any single thing at all. It was a short marriage. They had one child, and the court in that case just they weighed the evidence. I need to be a lawyer.
yes.
Because I don't want anybody to see
Yes.
the court felt. No. The court, in assessment of its evidence, right, and the fact that was before it, the wife was able to prove that she had put out the majority of the money to build this house, and it would be unfair and inequitable to give them a 50-50 split. And the thing about it is, sorry, go ahead, Jill.
I wanted to say something, right? So let's just say like you didn't do much, so you got married, but you know you pay a little light bill here and there, a little water bill, a little internet bill. How they gonna spend that?
Oh my gosh. Well,
JL, real going on to the nitty gritty. I feel JL must be having all them bills from the phone cards and all them things. And she like, if Ezra make a miss.
For your bill.
Let my lawyer talk to me, please, with what you say.
Listen, this thing has to be decided on the facts and the evidence presented before the court. If the two of you all presenting light bill and water bill, what do they have to split? We might just split in half. But if it is you saying, because in this particular matter, the guy was saying the same thing. He used to pay the light bill, he used to pay the flow bill. But that was not sufficient and it wasn't equitable because the woman still was indebted with the loans for the house. It was coming out of her salary every month. So it would not have been equitable to give him 50%. Having weighed all the factors which I was getting to. But you called us. So,
if it's his house.
If it's his house.
If he build the house, yeah. But I'm paying. That's not. I just want to do. Right. So if it's his house, but I got married to him and I pay the light bill and water bill and internet bill and phone bill and them kind of things. What again for that?
It depends on the circumstances of the case. So it depends on how long the marriage is, whether or not these things will taken to mean that, well, okay, my wife cannot afford anything else, so this is her contribution towards the home. It depends on the financial obligations that your husband might have after the divorce. For example, if it is he still is paying the mortgage on the house, how could they give you the majority? That's not equitable because he's still indebted with the mortgage. You might leave with a lump sum, but JL, seek independent legal advice on this, please.
No. This is not something personal.
I know.
I'm just saying, in case, because I have heard a lot of persons, because I always jokingly say, anytime you play mad, because we rent now, downstairs. So I always say, anytime you play match, I go take the downstairs and you go take the upstairs, 50-50. So I always say that now, so jokingly. So that's why I was like, okay, so then what I'm saying really does not have any weight. And I only knew this after I got married. So I was like, wait, that like I really thought that was something.
No, and the thing is, maybe you can't get 50-50 if you and your spouse or your ex-spouse rather decide that this is what you all want to do outside of the court. But once the court get involved, they have to make their assessment based on the considerations outlined in the legislation. And, you know, it's multiple factors that have to be taken into consideration against all the other things that exist that probably not even listed in the list. So it's not black and white. You don't just get 50-50. No, it's not black and white.
Okay, one more thing before I let you go, because I know I'm staying too long on the phone.
Yeah, stay long.
Let me just say, I know.
You should have been here. Then you would have gotten your time, but you take your time. Somebody else want to call JL.
I had different engagements. I couldn't do anything about it. But guys, listen, one more thing. Let me just say the husband was unfaithful. Right?
Mm-hmm.
So why the husband had to be unfaithful?
No, all right, but the wife was unfaithful. Go ahead, Jen.
No. All right, yeah. So the wife was unfaithful, right?
Mm-hmm.
She get anything there? Or they were saying no, she's wrong for that.
So one of the things that the court has to consider is conduct, right? And that would be considered as one of the factors that the court would look into, the conduct of the party. And, you know, whether the wife could substantiate the claims that the husband was unfaithful.
Like pictures and stuff.
Yeah. So that's just one of the factors that the court would consider. For example, if there was domestic violence, that would reduce your award. You would get a reduced award. If let's say if the court was minded to give it 50-50, once there was domestic violence, automatically that you're gonna get a reduced award.
If there wasn't domestic violence, but the wife went to the police station to make a report that she felt threatened,
that would be considered as conduct that could reduce the award as well. There. So this is what I'm saying. As I could go down my list now, right? The financial needs and obligations and responsibilities that they would have on the foreseeable future. The standard of living that they enjoy before the breakdown of the marriage. The age of the party during the age of the parties and the duration of the marriage. So how old are the persons? If the persons are young persons, the court might be minded to allow them to live with certain things because they could get remarried. They have their whole life ahead of them. But if it's an elderly couple getting divorced, which we have seen, chances are they say, okay, moms, dad, we had to say, hey, it don't make no sense. Or they go and sell their house, or they're living in for 40-something years. So one person might say, all right, I will live upstairs, you will live downstairs, things like that. The court will try to work things out like that because that is what will be equitable in a situation like that. Another factor that will be, and another thing to note too is the duration of the marriage. For short marriages, you are more than likely able to walk away with what you came in with. Right?
Nothing more.
Well, yeah, because it's a short marriage. But for medium to long marriages, in a situation like that, when the court exercises its discretion and weigh the different factors, it might go 50-50, it might go 60-40, but it's just to say that the shorter the marriage, the more likely what you came in with, you're going to leave with that.
Right? You call medium to 8 years to 10 years?
Yeah, so from 6 to about 9 would be considered a medium marriage, right?
Okay.
Another factor is any physical or mental disabilities of either of the parties to the marriage. So if someone is very ill, and I mean you have to evidence these things, of course. You can't just say, well, I have high blood pressure. You understand?
You have to come with the medical people.
No, and it is high blood pressure. Is it detrimental? Is it something that you have been managing compared to somebody who has like a condition or probably get cancer or something like that? These things would affect how much money one person gets over the other because they have this disease that they have to treat lifelong, and you need to factor that in as well.
Right.
Another thing is the contributions made by each of the parties to the welfare of the family, including any contribution made by looking after the home or caring for the family. And it comes back to what I said earlier, which was previously the contributions of women at home were not considered as contributions, so they would leave with a lesser award. But now we see here the legislation is saying non-financial contributions. So if you are a homemaker, you are still entitled to part of that the matrimonial assets and could walk away with more.
Okay.
Yeah.
Okay.
If I don't want to say in what situation, go seek a lawyer
Right,
and get your advice.
right. Yes.
But could walk away with more.
You said something and it had me curious because just piggybacking on what the gentleman had said. If you married, right, and you were talking long and short of marriage, and let's say you got married and the person they have the house and everything like that, and you came into that, and let us say he did a will, and so therefore he would have outlined in his will what he would have wanted, and he has children but they didn't know he did a will. Can those children still come into contest as opposed to not having a will? Because you mentioned once there's a will, so I want to know if that would make a difference.
Well, whether there's a will or not, you could still contest the probate, you know. If there's a will or not, for different reasons, you could say, well, the will wasn't valid. When daddy signed the will, he was on the deathbed, and you can't check that. He was under pressure, different things. So whether or not they could still try to contest the validity of the will or try to contest whether or not they entitled to a portion of the estate.
Will they be entitled, the children, if
So,
a will was made?
A will was made and he did not leave anything for them in the will? No. Once the will is valid, has found to be valid, no.
So the will has more validity than a prenup. That's where I want
Trinidad.
to go to.
In Trinidad, yeah. So
Okay.
taking us back to the very beginning, if prenups were automatically enforceable, then it would have applied in a situation where the person died and the agreements of the prenup would stand. But here in our jurisdiction, that is not the case. So if you make a prenup but you had a will, then in a situation like that, it is the will that is going to stand once they probate the estate. So it is a lot.
We have some questions that came in via the WhatsApp board. I think someone had asked something about, is it Atkins probably had a question. Let's see what Atkins had to say. He said, as someone in law, since prenups are not automatic, can someone maintain 1, a house, 2, bank account on their own name?
So even if you get married and you have this house, well, okay, the house might be something different, and it depends. The situation of the house depends, because if you married and the person would have made financial contributions towards improving the property value, all these different things for the benefit of the family, then they stand to get part value of the house. They may not walk away with the house, but you could have to pay them out. With respect to the bank account, even if you maintain a bank account in your own name, the court will have to weigh the evidence and say, well, okay, even though you had the bank account for your own name, did you pay for groceries from that bank account? Okay, yes. Did you pay bills from that bank account? Okay, yes. For all intents and purposes, was the bank account for the benefit of the family? Yes. Well, then the balance standing at the bank account would fall for distribution. But if it is during the marriage, you all were clear, this is my money, at no time this money was supposed to be your money, then if the evidence is tested and it shows on a balance of probabilities that was the case, then the court will leave you with your money in your bank account.
Going further, what if the person retired
and they have the pension?
Lump sum after working for number of years. And then she decided she wants divorce now.
That is going to fall as part of the distribution. And people get the shock of their life when they go to court and they find out that the gratuity and pension has to be split in half.
Whoa.
Yeah.
No, with all of this we're talking about, it speaks on the seriousness of marriage, one.
Correct.
As well as the need to be educated on, if you do go through a divorce in Trinidad, or you intend in Trinidad right now, I'm going to do a prenup, because a lot of, America has a lot of things and other countries have a lot of things, and we try to pick up some
Yeah.
things, but it's not making sense. So for those who thinking, okay, I'm watching those stars outside America,
Do a
and
will.
they did that.
But we have
Be
we
careful.
have had situations, and I think that drafters now, lawyers have been trying to draft the prenups in such a way that it would not, okay, for example, be unjust, or it would follow. Okay, so let's say in England they said it's not automatically enforceable, but if it is, you execute it in this way, the court might attach more weight to it and put the clauses in the agreement as a part of a consent order. But that is not because, so I just want to be clear, it is not because you made the prenup that you're getting the clauses in the consent order. No, it is because the court has weighed all the factors and have found that this is what is equitable, and in doing so they have made the clauses as a part of the consent order. But in a situation where you have people making prenups and stuff now, lawyers have been trying to draft it in such a way that the court is minded to give effect to it. But people need to still understand that just because the lawyers have been drafting it this way does not mean that when they go before the court is going to say yes.
And that's the thing. I think a lot of people, from the time they have that prenup and they believe, you're confident in the lawyer that is going to stand. I believe a lot of people are going to believe that.
It can stand, Devon, if you are not going to court.
If you're not going to court.
If the two parties say, okay, we want to be bounded by this agreement, then you will execute the agreement based on what you have written. But if one person says, I do not agree with this clause, remember, when you make a prenup, depending on how long after you have been married,
Right.
a lot could change.
Exactly.
You know?
Exactly.
A
People,
lot
their
could change.
mental, their emotions.
Before you get married,
yes.
you're not thinking about how you would dispose of your assets with respect to your children. Maybe you
The
might
breakdown.
you might
Yeah.
never contemplate that I would have blown up and have this big business, all these different things. So
Right.
a lot changes, and more than likely people contest the agreement, and that's why they go to court. But when they go to court, they get the shock of their life.
You are sharing so much, and I think we have to have another part. I don't think we have enough time to we have a few. We have a few. Okay, we can talk a few minutes. You did have some more information there you were reading from.
Yeah, so this, just to reiterate, so these are the things that the court would consider or has to consider legislatively when deciding the distribution of or the division of the assets. In the case of divorce, right, the value to either of the parties to the marriage or the benefit, by reason of the dissolution of, I don't understand that part, and I ain't have no time to explain that part, right? So basically, those things that I have just said, which is the income earning capacity, the financial resources, the financial needs and obligations of the parties, the standard of living and joy before the breakdown of the marriage, the age of each party to the marriage and the duration of the marriage, any physical or mental disabilities, contributions made by both parties, financial and otherwise. And the main thing here is that, and this is the key thing here that persons need to know, the court has to exercise its powers, right, to place the parties so far as it is practicable, and having regard to their conduct, so which is the conduct that we spoke about before, that could affect the award that the person has, just to do so it must be what is just, and this is where we underscore the term equity and not equality, right, in the financial position in which they would have been if the marriage had not broken down and each had properly discharged his or her obligations and responsibilities towards each other. So the court has a lot to take into consideration. It has to take into consideration all the factors of the case. It has to take into consideration all the circumstances of the case, It has to take into consideration the factors that I just called out there. It has to take into consideration the conduct of the parties. It also has to exercise this jurisdiction so far as it is practicable, right? And just to do so, which is, and the learning coming out of Passad and Passad is that, listen, this means that we have to do what is equitable. It is wrong to say that we divide this thing 50-50.
And I think there's a major difference there. Even, I kept that in my mind as you were making the distinction between the equal and equitable.
Yeah.
That we must understand that there is a serious difference between when we look at the 50-50, the 50-50 is equal, but equitable, you take other things into consideration.
But
somebody
is that
who
though?
can get and have your gratuity. You didn't work for this, why should I have to share?
Well, and I was married to you while you was working.
Yeah, but that's okay.
And I was helping pay bills in the house that you was living in.
You didn't pay no bills. I was working for hard sweat. Even before I met you, I started my job.
So
why should
For
you
better
pay?
or for
That's
worse?
So, Madonna, in your view, when it comes to marriage and somebody
this
working,
age?
no, just general.
Okay.
Oh.
In general, I was stupid. I didn't choose accurately. Yeah.
So let's talk about this age then, right? At this age, do you think that someone who a couple that gets married, when it comes to the stuff persons have, that they should be looking at that first even before getting married?
I think it should be considered because let's say like and listeners and stuff was saying that. Let's say I have $1 million, right? And you have 300,000, and we get married. I have a daughter. You have 5. Then now a will be put in place instead of a prenup.
Correct.
Because you weren't around when I was acquiring my $1 million.
Yeah.
Right? Let us work with what we have now. The thing about it is, of course, I'll give into whatever, and I wouldn't look back at that. But when it comes to what I've put aside for that and what I want for the children and that kind of thing, yeah, you can't be looking, because what happens is, and I'm talking from experience with no apologies, some people come at you looking at what you have and what you could offer, and they have nothing. And their mindset is in church. And they are going to look at that and it's real. So now we need to make wise choices and wise decisions and be mindful of what we're getting into. Because it has happened.
So then, we need to underscore why it is when we get married, the importance that we need to put on knowing that this is what we want. Because when this word of God says what God has joined together, let no man put asunder, even the law is recognizing that principle there. It is saying that if we want to put this thing asunder, we have to be sure. For example, when people go to get a divorce, sometimes, depending on the situations of the case, they are given mandatory counseling. There is a form that the lawyers need to sign to say whether or not they have advised the person to get counseling.
Right.
And that has to form part of the petition.
Before going to the divorce.
Yeah.
And
So,
even for the children as well.
correct. And then we have...
Mediation.
Okay.
And then we have when we are granted the decree nisi, we have 6 weeks to wait if you are the applicant applying for the divorce. We have 6 weeks to wait. All that is time the court giving you to see if you change your mind or not.
Okay.
Because what God had joined together, let no man put asunder.
Was,
so when you have to put asunder, you have to pay a price to put asunder. And people don't count the cost.
We have Brother Isman having a voice note. Could we play that?
Yeah, he didn't mean for it to come to us.
No, guys, this is a big topic, and we do encourage persons, as we said from before, make sure and go get your specific legal advice by your attorney.
Yeah.
Right?
Correct.
Right? We don't want persons to just run in any direction, except I think we would say this. When it comes to marriage is a very serious thing. It is not a light thing.
I think that's pivotal for people to understand.
Yeah.
I think we understand. And
I don't think
younger people don't understand because we sometimes don't get the right counsel in understanding the depth of how important it is.
And I even think that doing counseling, you need to make this a part of it.
Yes.
You need to explain what it takes to separate what you have joined together and what is at risk. And it's not a matter of, if people don't understand how traumatic it is to get a divorce. How emotionally draining, how financially draining it is. Only because everybody think they could get legal aid. But when you have to go and pay an attorney money to represent you, you have to go and read what this person have to say about you in these documents that you have been living with, have children with. When you
and
read
some things
these
could be
things,
brought up.
it is a lot. It is a lot. So let's be wise.
Yes.
When we getting married, when we choosing a spouse, that we know that this is until this person die. Because unless you have the finances and you have the backbone to go through, then that's what it would be like.
All right, so we have a few more minutes left. So we continue in it.
Yes, we'll continue.
And so a number of the topics that came up, a number of the questions and that kind of thing, I guess us who have been there and done that know it's not easy. And that's why overemphasizing, please choose accurately and don't even be fooled sometimes by what is brought before you. Get good counsel and listen to the others as well who would see what you're not seeing. Do research.
Correct.
People find it offensive to do background checks. No.
But I mean, that speaks to just the transparency, because if you're getting married to somebody, you need to have transparency before you enter into that marriage. I shouldn't have to get a prenup to know what am I getting myself into. We don't need something to tell us that. We should be seeking that in any event,
We let's take this final caller. I see we going a little longer. Hello, good evening, caller. Welcome to Kingdom Principles.
Hello, good night. If two persons is married and separated.
Hi, could you move away from the radio, please? We are getting a huge feedback on our end.
Okay, if a person is married and separated over 30 years and the both of them agree to take a divorce, would it have any problem there?
Sorry. Yeah. No, because you can't. Okay, so there's one. Okay, let me not go into too much of the legal things. The simple answer is no if you all are consenting to get the divorce. You don't need it. It will not become contentious. The only thing that becomes contentious is when you all don't agree on how you are going to divide the assets that you all would have had together during the marriage. So if you all agree that we still live and separate for such and such time, let's get a divorce, because I don't know if you know, but I guess not, but you can do 2 years with consent, 2 years separation with consent, or 5 years separation without consent and go and get a divorce petition, right? File for a divorce, sorry. So no, you won't get any issues there.
You just still have to get consent.
For which one?
Years.
After the 5 years? That's not in the law. I don't know. I don't know about that.
No, because the court, if they can't, if you just go and you want things to be public, then they'll put it in the papers that they can find the person. And if not, then they have to find him and he have to sign.
Well, that sounds like issue with service, but we'll talk about that off here, right? But for the caller, shouldn't be an issue, especially if the two of you all agree that you all want the divorce. So you wouldn't have to look for him to sign, as Madonna said there. He will come and sign.
I have a question. In regards to divorces, are there more persons going for divorces that are of the younger generation or the older generation in your experience?
Well, in my experience, it has been younger.
More of the younger generation.
Yes. Persons who have been married for like 3 years, 4 years, around that 5-year mark especially is when you see people coming to get a divorce. But I mean, as Christians, we know that society is becoming more and more morally depraved. People are making decisions based on feelings and self and all these different things. So it is expected to see an uptick in divorces because men are becoming lovers of themselves now.
Right.
And marriage, you can't be a lover yourself.
Yeah, because it's a partnership. We enter in a partnership. Yes.
So,
Akil, it's good to see that you and your wife has been together for more than 5 years, right?
This year will be 5 years.
This year will be 5 years? Okay.
December.
December. You
How
have it
does it feel
locked.
to be married to an attorney, though?
Yeah. How does
Oh
that
my
feel?
gosh, this is not what we come to talk about. We didn't come to talk about this.
And as a Christian, how do you feel as an attorney?
Well, I'll let him answer first.
All right.
It's good.
You can come a little close.
We're here. Okay.
Yeah, come
No,
on.
it's good. And as you would see with an attorney, you have to, say as little as possible. So it's good. Don't give too much details.
I don't believe this.
But it's good, man. It's good, and it's good to see that it's being used for the kingdom.
Excellent. It's good to have that feedback. We have a message coming in from Zalaka. I hope I'm pronouncing the name correctly. Suknanan. Oh, it's his message. His or her message is: are there other reasons for divorce other than adultery? Oh, we're going into.
Yeah, there are many other reasons, but remember, at the end of the day, there are okay. So there are 5 fault finding grounds, but there's one fact, which is unreasonable behavior. Right? So we have the consent, we have the 5 year separation, we have the you can't be expected to live with the person, I don't know. Well, people who are familiar with divorce will know about that. But it's just to say that yes, there are others. And another thing is, people think that because you file for divorce, you will get it. There have been divorces that have not been granted.
Oh.
Yeah. Because you have to prove your case.
Oh.
There have been divorces that have not been granted.
Okay.
Yeah.
Though the person committed adultery.
Yeah, because when you allege that the person commits adultery, you actually have to get the other party to come on record saying that they did it.
Wow.
And that they were with the person, and they're not going to come on record for that. So you have to find another fault finding fact then, basically, to prove that you should get this divorce petition.
Wow, that was news to me. That is news.
Yeah, he could be sleeping out,
Yeah,
with
but-
Mary Jane every day.
But what in a case like that, you basically say that the person has behaved unreasonably, and you can't be expected to live with the person, and then you outline what are the unreasonable behaviors that they would have exhibited during the marriage that would make it like that makes it basically you can't live with the person. You can't be expected to live with the person because the emotional, the financial, and set out your facts, but go to a lawyer and they would advise you.
Let me ask this question, right? We're going a little extra, folks, to our listeners. We'll be closing off at 8:13. So I want to bring it back to the prenups. We started with the prenups.
Yeah.
And I wanted to ask, now we kind of like focus on persons who have stuff. But what about a couple? And we could go over to Canada, America, all those other places.
Yeah.
What about people who don't have stuff and they're coming in and they want to do that prenup? You see people doing that as much.
Yeah, but if you have, okay,
But I've
if
heard
you do not
that
have
people doing
stuff,
yeah.
what are you trying to protect?
But that's the thing, because I'm hearing people are
So this
considering
is
doing it.
so this is where you find you could do like a post-nup, which is during the marriage, and you have things and you have acquired things and you settle the terms of the agreement, whether you're intending to be married or you're intending to get separated. Now, our courts have been minded to give effect to the separation agreements more because, at the time, this was the mind of the parties when they were going to file for divorce because they already separated. But with the post-nup, it comes right back down to what I said, which is the court would just consider it as one of the factors. But to me, just thinking about it logically, I mean, if you do have nothing, what you're going to lay out as your terms in your agreement, because your terms in your agreement is laying out the
things that you
assets,
actually
the
have.
finances, the stuff that you have.
So then the information that is shared online, there's a lot of information on YouTube and whatnot about someone could say, well, when we have a business, we're catering for that and we're putting that as a part of the prenup. That is not a reality.
Well, when we have a business means that at
Because
that
the
point
plan
in
is
time
always
the business didn't exist.
It didn't exist, yeah.
So maybe you could say all other income that we might derive at at a later point in time.
Yes.
But even then, it is best to set out the terms of the agreement clearly and be as specific as possible, so as to avoid confusion when you want to give effect to the agreement, whether it's out of the court or in court. You understand? So for me, it's like even if you put that clause that speaks to in time or in future, you might still need to come back during the duration of the marriage and revisit the prenup, which will no longer be a prenup. It will be a postnup because you're married at that time.
Right.
And you can't vary the prenup because the prenup is before you're married. You understand? So,
And two parties have to have their, well, each party has to have their own lawyers. That's what I
yeah. You need to have independent legal advice. There mustn't be any undue influence. If you... Is a caller?
Yeah. Take a call. Hi, good evening.
Good evening. I have a question to ask.
Okay.
Do married people commit adultery or fornication?
That's our main topic.
No, that's a whole other
conversation. Yeah.
Tonight we deal with prenuptial agreements.
So you probably could call us in the open forum. Open forum is every final Friday of a month, each month, and you could present that question in that particular setting. All right, caller. Well, thank you for your call. We have pretty much run out of time.
Yeah.
Whitney, I just want to thank you and your husband for coming through and sharing this wonderful information.
Yeah.
Very eye-opening. I want to give you a few moments to give your closing words, anything you want to highlight as we close off.
Well, what I would say is that I know for some persons who are listening, this information has come to you as a shock. Especially if you have been contemplating getting a divorce or marrying someone and looking at the options to protect what you have. Marriage is of God. It is God's institution, and it can only work when it is done God's way. So seek the Lord concerning being married. Seek counsel, as Madonna would have shared, to be sure that this is what you want to do, because it is not just we will divorce and go and live our separate lives. It is so much more that goes into it before you actually get to that point. And my encouragement is, God said, in the beginning, it was not so. It was not so. So let's try and be reconciled and keep our families together. Yeah.
Amen. Thank you very much, Whitney. So
You're welcome.
We are so glad to have this conversation, and glad for you who joined us, who listened, who gave your contributions. It was great. So I wish you all a wonderful night, both you and your husband. But now it's time for us to wrap. So
Some questions off here.
I have a feeling we might have to bring him back next week. Please God. We'll see what happens. Guys, remember, wisdom is the principal thing. Therefore, get wisdom. But with all thy getting, get understanding. Brother Dev is out. Donna?